Okay, so we could begin. Let's see. It's working. Let's try to see. So,
I'm actually started. I got to go. Call you back later.
okay.
Bye.
I'm gonna have to ask everyone else to mute his or her microphone so that we don't have any background noise. Somebody's microphone is on. Can somebody turn, whoever has his mic on, can you please make sure that that's off? Please make sure that you mute your mic so that we don't have any, thank you, Peter. We don't have any background noise. Okay, there are two things I'd like to do today. That was somebody's microphone, that wasn't mine. Please make sure to turn off your mic. Okay, there are two things I'd like to do today for the purpose of revising for this assessment. The first one is to look at how to answer case problems well. And the second one would be to look at the topics. I'd like to explore that aspect of the formal part on how to answer case problems, mainly because we often think that what we need to do is simply to have knowledge of legal principles or knowledge of case law. And then we'd end up having exactly the same mark as somebody else because we have the same knowledge. But that's not really true. There would be a major difference in terms of the mark from the viewpoint of how the answer was actually made or how the answer was given. So we're going to have to focus on that. So in other words, even if there are two persons whom we can assume to have exactly the same amount of knowledge, we can be sure that their marks will never be the same unless they copy it from each other. Their marks will never be the same because they will not have the same communication skills. They will not have the same skills in terms of presenting their answers. Okay, so that is crucial because sometimes we end up saying, oh, how is it that this fellow student of mine has a higher mark than I do? What's the reason for that? We know the same thing, but that's exactly the point. Even if you do know the same things, the way you present your answers matters a lot. And as far as being a lawyer is concerned, you can easily assume that most lawyers would probably have the same amount of knowledge about the law, but the ability to advocate a position, the ability to argue a point, makes a huge difference in terms of being able to convince the judge or not that your position is actually the correct one. So we're going to spend time on that because I'm hoping that if you're able to enhance your ability to present answers, you're likely to have better marks, not just for constitutional law, but actually in all of your other courses in law. So that's one. So the ability to come up with very good answers. And secondly, then, we'll focus on the substantive part, and that's when I'll be discussing again certain constitutional law principles which we apply to case problems, which will then aid you in answering the final written assessment. So there are two parts. Now, what I'm going to do is that after we finish the first part, which is the formal part, I will request that we take a break for 5 minutes because I'd like to kind of force you in a way, or force most of you, not really force, but ask you really to spend time doing the survey. So just to give others the chance to do the survey, I'm just going to have a short 5-minute break, and that allows us to just to catch up with some of the things that we may want to do. And at this time, I would imagine that no one else will be using the license anyway. I don't think Wayne Jones will be using the same license. So if need be, we can go beyond 7 o'clock. Okay? So any questions so far before we proceed? Anything you'd like to raise? And I'm just going to bring up the chat box. Oh, sorry. Just going to bring up the chat box to make sure that I'm aware of what's going on. Okay, from Cheryl, the survey has been done. Okay, thank you. Now, somebody else still has his or her mic on. I don't know who that will be, but I'm getting some background sound there. Can you please make sure, whoever that might be, to turn off your mic unless you want to say something to the rest of the class, because it can be distracting. Thank you. That has disappeared, so thanks so much. So let's move on. Okay, let's just talk about the IRAC and the CIRAC format. There's actually a logic to the IRAC or the CIRAC format. Both are the same in terms of the structure, mainly because you first begin by identifying what the legal issue or legal issues are, and then state the rules that would be relevant to addressing the legal issue, and then apply the legal rules or principles to the facts, and then come up with a conclusion. Now, the CIRAC format simply means that you begin with the conclusion at the very start. So you either say, you probably say that the law is valid or not, and then you state the rule. Now, as I will do later on as well, what I'm going to do is to actually show you examples of the answers that I've crafted, just to show that it's important that we practice what we preach. So I practice what I preach. So we're going to examine some of the answers that I've actually provided to you in the form of suggested answers to discussion questions. And let me just remind you actually that it's crucial for you to go through the discussion and the answers to the discussion questions that I gave, because in a sense, they actually summarize the key principles of constitutional law to such an extent that I would argue that if you actually go through the suggested answers and discussion questions, go through the lecture notes and probably listen to the lecture podcasts, there's no reason why you will not do well in the constitutional law exams. The textbook of Ratapalo and Crow, they'll be very helpful, but I would strongly suggest go through what I've created so far, go through my lecture notes, go through my suggested discussion answers, because there, not only will you be able to see the important legal principles and the way they're applied in cases, but you will see the process by which I attempt to answer the case problem. So it gives you a good guide on how do I come up with a good answer. In fact, the suggested answers I had to the legal memorandum can give you an idea on how best to address certain case problems, because that was a model of what I think is a good answer. Okay, now, so there is a logic to the IRAC format, mainly because it's essential that, especially from the viewpoint of answering a case problem, it's important that we figure out what exactly is the legal issue in the first place. What's the problem here? Because if we do not know what the legal problem is, if we do not know what the legal issue is, what's the point of stating all the legal rules or stating legal principles? Remember, there are so many legal principles involving constitutional law. Hold on. Yeah. We don't have an actual exam. It's a written online assessment. Just saw the chat there from Jerry, who had a question. So it's not an exam. It's a written online assessment. I think you're given 30 hours, if I'm not mistaken. Now, so going back to the IRAC format, there are so many constitutional law principles that are there, as you've seen in the book. And if, without knowing what the issue is, you then start spouting or just throwing in your answer all of these sorts of legal principles and rules, it makes no sense to the reader. It's like, what are you trying to tell me here? You know what I mean? So the legal principles that you state there, the legal rules that you state there, are ones that are directly connected to the legal issue that you've identified, because those legal rules and principles are meant to address the legal issues. So it's much like a doctor. Before a doctor is even able to give you a prescription or a script, he must know what the medical problem is. Okay? The medical problem is the equivalent of what the legal issue is. Now, in the legal memorandum, I came across quite a number of legal memorandums where the legal issue was not even identified. Now, I am not saying that it is essential for you to say that the legal issue in this case is blah, 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 blah. That's not even necessary. Okay? Because if you see my model answers, I didn't do it that way. I didn't say that the legal issue is blah, 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 blah. You don't do that. Okay? And we're going to examine that shortly. But Because when you first see the IRAC format, the initial conclusion on the first sentence there, or typically in university you call them the thesis statement of the central idea. By reading that first sentence, you know what the entire discussion is all about. That single sentence tells any reader what the discussion is going to be all about. Okay, that's a thesis statement. It's a central idea. So the issue is crucial, because if you don't know what the issue, anything else you say is going to be pointless. It's going to be irrelevant. And remember, I'm never going to be mesmerized by so many of the legal principles you state there, because remember, this is an open books assessment. So if all you end up doing is to just copy and paste or paraphrase legal principles without saying where that is headed, it's useless. You're just wasting everybody's time. So it's crucial, the issue, then apply the legal rules or the principles that are relevant, that in terms of addressing the legal issue. It makes sense. See, you can see the logic, can't you? Now, after you know what the issue is, and therefore you say, oh, so if this is the issue, these are the legal rules that we need to apply or use to resolve the legal issue. Now, these are the facts. We then apply the legal rules to the facts. That's crucial, right? Because then, if all you do is to just, state the legal issue, it doesn't tell us anything. It's crucial. You need to apply the legal rules to the facts. Now, that is oftentimes the problem, and I'm going to discuss the paraphrasing there, because oftentimes, if you will remember, most of you'll probably come across a comment I made, and I'm not exactly sure what John did, but at least for those that I personally marked, you'd probably come across a feedback I gave where it is better for you to paraphrase this statement from Justice blah, blah, blah. Why is that important? Because that's important because oftentimes, a decision or a ruling from a judge or the statements of a judge are quite lengthy. Now, so typically, you'd probably end up copying 5 sentences of a paragraph. My internet connection is unstable. Now, the problem there is that sentence can actually be dense. It's possible that it can be read in different ways. It can lead to any possible conclusion. So in other words, to a great extent, because it is just too broad, because it's just a legal principle, it means nothing. Your job is to tell me, so what? So this is what he said, but how does that relate to what we're talking about? It's important, therefore, that you're able to use the legal principle to your advantage. So you're actually saying you're going to paraphrase the statements of the justices to say, this is what the High Court said in this case, blah, blah, blah. That's your own statement. And because you're using it, you're using your own words, you're making sure that you're using the case law to back up your conclusion at the end. Now, so that's one. So one reason why you need to paraphrase long quotes, and you will see that I don't do that in any of the model answers. You will notice I've summarized the key idea in what the High Court said in a case. That you will see that. You would not see me coming up with 4 sentences in any of the suggested answers I have. How many problem questions did we have? I think we had more than 51 or 52 or even 60 or 70 even. You will not see me coming up with just doing a copy and paste of a long citation of what a justice said. I paraphrased them to be able to use what he said or what she said, one of the justices said, to strengthen my answer to the case problem. And that's what you need to do. That's one. So you're paraphrasing it, meaning you're using your own words in order to support your answer or to back up your conclusion. And so that's one. The second aspect is, if what you do is simply to copy and paste a quotation from a justice, where is your intellectual contribution? Let me repeat. If all you do is copy and paste lengthy statements from justices, where is your intellectual contribution? What have you shown me? Nothing. I could get a 5-year-old kid who's very good in using computers and ask that kid to copy and paste one of these quotes, and that's it. There is no intellectual contribution. You need to show that you're contributing something in your answer by at least paraphrasing them. That's crucial. Okay? Now, especially for lawyers, imagine if you come up with a pleading and all you do, is throwing, one quotation after another. It's like it's a hodgepodge. It's like, so what? Where is this all headed? There is no argument here. Where's the argument? What are you trying to tell me? It tells me nothing. So you need to be able to paraphrase. Now, if you're able to, after you go through these techniques that I've suggested, if you keep this in mind, you practice it a lot, I can bet you'll come up with fantastic answers in any course. Okay? Now, the other thing we need to remember is that at the end of the day, what is lawyering about? Actually, lawyering is about persuasion and advocacy. You're advocating a position. You're arguing a position. Even if it seems to be a losing position, you're still trying to argue your case that you are correct. You're making an argument. When you go before the judge, you're making an argument. You're making your case. You're trying to persuade somebody. You're advocating your position. Now, when you read there for an answer, it's like you see the passion there in yep, that's from Jamie, making an authority statement. Tony, the answers are already there. All the answers from not week 1, but from weeks 2 to 11 are already there. They're there, including all the lecture podcasts are now in Moodle. So there. Now, going back, where was I? I lost that. Persuasion and advocacy. Kind of lost my statement there. I got distracted by the chat. What was I talking about? Somebody
arguing a position.
Oh, yeah. Thank you. Now, a good, an HD answer is when you read it, you can feel the passion. That's what lawyering is all about. The best lawyers are the ones who are very persuasive. You can feel the passion, the energy. Not stayed, somebody who's stayed, passionless. You can see the fire, it's authoritative, as Jamie said. You're advocating a position. So therefore, in fact, the worst kind of answer you'd probably come across is somebody who has no position at all. It's like, it can be this, it can be that, without, saying why. Be authoritative. You have to be convincing, meaning if you're not even convinced, how do you expect the marker to be convinced? You're convincing the marker that you are correct. In fact, at the end of the day, and actually that's the reason why there were a lot of people who got HDs in the exam. Was that you can tell the truth? There were a lot of people who got HDs in the legal memorandum assessment, even if their answers were wrong. Okay? Because, and that's really what, there is really nothing really certain in the law. You will see justices, if everything was so clear, there wouldn't be any dissent among justices. But oftentimes you come across divided courts. And so in other words, what is a dissenting opinion today may become a majority opinion at some point. Right? So, but again, the reason why what is a dissenting opinion today becomes the majority opinion at some point is because there is somebody who's very good at making a case, arguing a case. So that is what answering is all about. There has to be, it's about persuasion and advocacy and convincing the marker that, you know what you're saying and that your conclusion is correct and it is the correct one. Now, thirdly, the other thing you need to do is, that's why you need to be able to come up with a clear, concise statement at the very start, which is the central statement or the thesis, because you're trying to tell the marker or any reader what you are about to say. Put it this way, it's actually possible for me to come up with a marking guide, to come up with the suggested answers, write what the answer should be, give it to another person, and let that person do the marking for me, even a non-lawyer, okay? Now, that non-lawyer will actually be able to mark well if you actually state from the very beginning what you're about to say. So the mark of a good speaker or the mark of a good writer is that from the very beginning, we know where we're headed. So tell us what you want to say. There has to be a roadmap. That's why I think you will come up with comments like, I'll say, where is this headed? What are you trying to tell me? Create a roadmap. So even if the good storytellers, the good novelists, tell you at the very start where this is headed. Okay? Now, Like a preposition, kind of, yes. So Cheryl, good solid opening argument. So from the very start, members of the jury, I will show you that blah, 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 blah. Otherwise, you know, if you were in front of a jury and you don't say, members of the jury, this is what I'm about to do, it's like they're waiting. It's an anticlimactic thing. Like, okay, we're waiting for something. But what exactly is going to happen? Which is why, if you notice, when we have a tutorial, let's say from the very start, this is what we hope to achieve. So it tells you where we're headed, right? Okay. Now, the other thing, the problem with some of the legal memorandums I have, and in fact, yeah, from Amelia. Let the marker decide if they want to. Exactly. It's like read the journal articles. If you came across a journal article, whether it's about law or social sciences, you will notice that there's an abstract and there's an introduction there. When you see that, it tells you, should I read this or not? Is it worth my time or is this rubbish? Same thing with the news. If you read the news, the first paragraph will tell you whether or not that is newsworthy. Meaning, is that worth your time? It doesn't, the important part is not at the back, it's at the beginning. Because it tells you, is it worth reading this? So that's important. Now, so that's good. I think you feel that. Peter, you need to engage the audience. That's right. So it's about capturing the attention, engaging the audience. By making that strong statement, you're beginning to engage the audience. Is it worth reading? Is it worth my time? Very good. So I hope you see that. Now, the other thing that I don't like, and any marker will not like, is you would say, and this happened in a few of the legal memorandums there, where they would say, the case of Boilermakers talked about, that judicial power should only be with Chapter 3 courts. Or it would say, for this purpose, read Boilermakers' case, that type of thing. The thing is, or you would say that it's in the Constitution that, there is judicial power. The point is, it is not my job to add material that is not there. Okay? It is not my job. It is your job to put on paper everything that you want to say. It's not my job to do research for you. I don't have to read the case. I don't have to read the legal principle. That's your job. So what's not there is your problem. You know what I mean? It's not my job to supply missing statements. It's not my job to supply missing legal principles. You're only assessed on the basis of what is there. And I cannot make an assumption that you actually know something. I can't do that. It has to be there on the assessment piece itself. In other words, if I were to show around what you said, we all agree what you stated, about what you stated. We can't have a disagreement because it is written on paper. So do not let the marker state the missing facts, okay? And don't make the marker figure out what you are trying to say. Now, what else? The other thing is, it's really important that you don't just name drop cases or name drop constitutional provisions. Explain what they say. And when I say explain, you mean paraphrase. Because I've come across so many instances where a case has been cited, good, but it doesn't tell me, okay, so how is this case relevant to the problem? So it's insufficient for you to identify what the case law might be or what the legal principle might be. You need to be able to explain it. Okay. So see the conclusion first. So plenty of examples in my suggested answers. So paraphrase. Now, the other thing about law is it's really difficult to plagiarize the case problems. Really difficult. I came across at least one where I felt the English was quite good, but actually I knew that person, that student, did make that himself. You know why? In fact, most likely, you've probably heard of those stories where some students now in law schools pay some professional writer to do an assessment for him or her. And I think there was an attempt in the legal memorandum assessment where there was a professional writer who likely prepared the legal memorandum for one of the students. But it was obvious that it wasn't the work of the students. Why? Because all the person did was to talk about, what happened in Australia. Australia is a democracy, blah, 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 blah. Totally irrelevant. obviously that student got a failing mark. And by the way, because you might think that, and I'm not blaming some of the students, because some students have actually asked for a review of their marks. Some of them made the case that I gave higher marks than John. That's true. In general, I did give higher marks than John. But the flip side of that is that unlike John, I actually failed 14 students. So there were 10% of the cohort, those who submitted, who got HD at least 90 or above. But there were 14 students, which was again 10% of those who submitted, to whom I gave failing marks. So I kind of, I'm quite fair. I mean, if you're very good, you'll get it. If you're not doing well, you're going to fail. And I do fail students, although I try to avoid that. And really, to me, it is inexcusable if you have to not do well. I'm not even saying failing. Failing is not an option here. I would be severely disappointed if anyone fails the final written online assessment. I'd be severely disappointed. And I have to ask myself, how did the student fail? That is not a question anymore. The question is, how do you come up with good marks for the final written online assessment? Failing shouldn't have to happen. If you listen to this lecture podcast, if you're part of this, if you went to this tutorial and then went through the lecture notes and went through the suggested answers, I'd have severe difficulty understanding why you would fail. You would have to do well. So the question, the challenge for all of you now is, how do I come up with very good marks? That's what I'm hoping to see, that there will be more students hitting the credit and the distinction side of things, not just passing. Is that credit? I can't remember the grading system, but I'm hoping many of you will get 80 or more. I don't want to see marks clustering around 75. I don't want to see that. Okay? So where are we? So plagiarism is difficult because, again, if you get somebody to ghost write for you, that person is unlikely to come up with a persuasive answer, because this is we're talking of law here. They need a legal background to be able to answer questions, and they have to do it in the right way. Okay, so no waffling, because it's not going to make sense. So the other thing was, there is no point in excellently stating legal principles or cases that are irrelevant. So in other words, even if you come up with a very good summation or a restatement or a paraphrasing of a case of case law or a legal principle, if they are irrelevant, you don't get any marks. You know what I mean? You have to ensure that all the cases that you cite, all the legal principles that you cite, strengthen the argument that you're making. Otherwise, it's pointless. Which is why, as I said, from the very beginning, it's always crucial to identify the legal issue. That's the most important thing. You miss the legal issue, forget it. Your answer is going to be wrong. It's like, before we talk about, like we're headed somewhere, we need to know where we're headed. Otherwise, if you're driving in a car and you don't know where you're headed, where exactly you're going, it's pointless. You can go anywhere. The identifying the legal issue tells you the direction, the path you're taking. That's crucial. The ability to identify what the legal issue is. Okay. Now, as I said, I do what I preach. So what we're going to do in a short while is to look at some of my suggested answers. And you will see that what I'm telling you now is exactly what I'm doing with my suggested answers. In fact, we're going to examine that. Oh, the other thing, before we end this part about techniques in answering case problems, let's talk briefly about sources of law. Okay? It was a good thing it didn't happen often, but I found it problematic that in some cases we had students in the legal memorandum assessment who were actually using my lecture notes as a source of law. It's like, Dr. Oyson said this. I'm not a source of law. I'm not even, my lecture notes are good for teaching, but you can't cite me. You can't even cite Ratnapala and Crow. You cannot cite a textbook. Did you get that? A textbook is not a source of law. You don't go before the judge and say, Your Honor, according to the book of Ratnapala and Crow, that's bloody useless. The textbooks are good. They, in a concise form, in a single tome, you have a good sense of what constitutional law might be. But this is not a source of law. The source of law would be the statutes, the Constitution, or the cases of the court. Those are ones you cite. I've come across cases where somebody was using internet sources. I mean, my goodness, how the hell, why are you using, okay, sorry. I don't want to be offensive. I didn't intend to offend anyone. Okay, let's be clear. This is just a clinical thing. I don't mean to offend anyone because I don't want to get into trouble. Okay, I'm just expressing my views and I didn't mention anyone. So don't get offended, please. Okay, let's be clear. Let's be clear here. We're being clinical. I don't intend to offend anyone. Okay, now, don't use an internet source. What the hell is going on? Internet source. It has to be court, high court cases. Okay? Textbooks, out of the question. Now, the only time you can actually use a textbook is when there is a gray area in the law. There will be times when the law has a gray area. You're not too sure, right? Because, in other words, you're confronted with a case where the High Court has not made a ruling. Fine. The High Court has made a ruling. So how can you argue then? Then you'd probably say, according to Ratnapala and Crow, this is likely the correct one. Or you'll probably say that Justice so-and-so speaking outside of court said this. That's fine. Okay? But in all other cases, the only sources of law would be statutes, the Constitution, or the High Court cases, or even the Federal Court cases. Now, better yet, it should be the High Court cases. Sometimes the Federal Court cases are fine. Okay? But obviously, if there is a contradiction between what the Federal Court says and the High Court, obviously, the source of law should be the one coming from the High Court. So, would that depend on what level of court you're arguing in? As far as state laws are concerned, obviously, if you're talking of the application of state law in the states, certainly you're going to be using decisions by the states because each state will have its own legal regime, and therefore, to that extent, the decisions of their own courts will be more important. Meaning, if you're in New South Wales, you're not going to be arguing from the viewpoint of the Queensland Supreme Court. Okay, that's fine. But if we're talking of a federal matter, if you're talking of a Commonwealth matter, obviously, you base it on the decisions of the federal court. You base it on the decisions of the High Court. So clear. So I guess that's the end of my techniques in answering case problems. Do you happen to have any questions? Questions? Okay. Now let me just, as I said, I try to, so let me just be clear. It's 6:35, but I'm more than happy for us to go beyond 7. If you're happy to stay on, stay on. Now, so I just wanted to emphasize this because I'd like to see you coming up with better answers this time. I should have actually done this before, but I had asked a Laws 12061 class in the tutorial. I was asking them, would you like some help in coming up with good answers in legal memorandum? They said, oh, we know that stuff. So I just assumed that, it wasn't necessary for you as well. But I remember now, many of you might be, year 1 students. So yeah, I should have done this, but it's never too late. The final written assessment is worth 50%. And remember, if you master these techniques that I've suggested, you'll move along in your legal degree as federal law students who are persuasive and very good at arguing, and you know what you're doing. So you're not just answering a question. You are advocating a position. Okay? So remember, this is not just about answering a question, you're advocating a position. Got that? I hope that's clear. Now, so what I'm going to do next is to just go through some of the ways that I answered questions. Like, do I have to ask somebody to read this, or do we read this on our own? So, okay, I'll probably do it myself. So there's the question there. Patrick, are you there?
I am.
Patrick, can you just read the question for us, and I'll read the answer. If it's
okay,
fine.
Yes.
Thank you.
Question 31. In order to add certainty to the validity of certain high-value commercial contracts whose subject matter had a commercial value of 100 million or more, Parliament passed the Important Commercial Contracts Law, under which the Federal Court of Australia has jurisdiction to review and make a declaration on the validity or invalidity of proposed high-value commercial contracts upon the joint judgment of all the parties to a high-value commercial contract. Rule on the validity of such a law.
Okay, thank you, Patrick. So this is my answer. The law is invalid. So it tells you straight away what my conclusion is. And then I'm citing the rule. In the case of R versus Kirby, ex parte Boilermaker's case, the High Court ruled that a law that vested non-judicial power on Chapter 3 courts is unconstitutional. It also stated in Huddard Parker versus Moorhead that judicial power may be exercised only in relation to matters as provided in the Constitution. The Re-Judiciary Act defined a matter as involving a controversy concerning some immediate right, duty, or liability to be established by the determination of the court. So there's the rule. Now, in the instant case, in this case, meaning the facts there, the jurisdiction to review and make a declaration on the validity or invalidity of proposed high-value commercial contracts upon the joint agreement of all the parties patently does not involve a matter or controversy concerning some immediate right, duty, or liability to be established by the determination of the court. Hence, since the law seeks to invest non-judicial power in the Federal Court of Australia, which is a Chapter 3 court, it is unconstitutional. Right? In fact, if you will remember the suggested answers I had in the legal memorandum, some of them were quite concise, direct to the point. Now, you will notice I did not state the legal issue. I did not have to because I knew where I was headed. That's helpful to you. Okay? You don't have to say, it's actually quite elementary to say, the legal issue in this case is blah, 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 blah. You don't really have to do that. And you will never see that in a good pleading. But they will flag and tell you, where the discussion is headed. Okay? Now, moving to the next example, and as I say, it won't take too long, just bear with me. We're just going to come up with 4 examples just to tell you, I follow what I preach. I mean, I do what I preach. And you can go through all the suggested answers that I gave. Patrick, can I ask you to read the discussion question?
Yes. The Commonwealth Parliament passed the Business Liability Insurance Act requiring certain types of businesses to get mandatory business liability insurance. It also required insurance companies that wish to engage in the business of providing business liability insurance to secure a license and pay a license fee based on 2% of their projected sales revenues for the fiscal year. License fee adjustments are to be made 3 months after the end of each fiscal year. XYZ Insurance Limited seeks to challenge the law. On what ground can a challenge be made? Advise the company on whether its legal challenge is likely to prosper.
Thank you. I would advise XYZ Insurance Limited to challenge the constitutionality of the Business Liability Insurance Act for violating Section 55 of the Australian Constitution. Under this provision, and this time I'm not paraphrasing it because it's a constitutional provision, laws imposing taxation shall deal only with the imposition of a taxation, and any provision therein dealing with any other matter shall be of no effect. In violation of this provision, the Business Liability Insurance Act deals with both insurance and taxation. Now, I'm going to explain further. The subject law requires insurance companies that wish to engage in the business of providing business liability insurance to secure a license and pay a license fee based on 2% of the projected sales revenues for each fiscal year. The said license fee is actually in the nature of a tax. A tax was defined by Chief Justice Latham in Matthews versus Chicory Marketing Board as 1, a compulsory exaction of money by a public authority for public purposes and enforceable by law. The license fee squarely meets the definition of a tax, being a compulsory exaction of money by a public authority for public purposes and enforceable by law. Can you see the logic so far? There is a logic. I'm connecting the facts to the case law. Now, as well, and I'm looking now at the challenges. The license fee cannot genuinely be considered a license fee, and hence is actually a tax. to legitimately be a license fee, the fee imposed must be an amount that is commensurate to the cost of implementing a regulatory scheme. And I'm citing case law there. Or must bear a discernible relation with the value of the cost services rendered. Citing case law again, in regulating the importation and exportation of dietary supplements. Can you see how I use case law? I just picked some key points there. So in other words, that's my intellectual contribution from so many things that were stated in these cases. I picked up the crucial points that the justices said to strengthen my argument. So in other words, if I were to stick in here a paragraph, copying and pasting statements of a justice, the reader will not know what exactly is going on here. Okay? So should we follow a simple structure when presenting an argument? There is a structure. Yes, that's the IRAC format. That's a simple structure. There's a logic there. Right? There's a logic. Now, under the facts, so as you can see, I stated my, hold on. Are you able to indicate the total word count? There will be a word count limit. I got about 1,500. I don't want to be deluged by so many words. There is a word count. I can't remember what it was, but we're going to check on that. Now, does it require headings? Not really. It's up to you. It's not that important. Now, going back here, so I've stated the conclusion. I know where I'm headed. I know what the issue is. And I've stated the rules and the principles, citing appropriate case law, paraphrasing them when necessary. Now, and then the application under the facts, the license fee is based on 2% of the projected sales revenue for each fiscal year of insurance, blah, blah, blah. In the business of providing business liability insurance, that amount is likely to far exceed the cost of implementing a regular scheme and hence cannot generally be considered a license fee. So can you see the argument there? It's clear where we're headed, right? Another one. Patrick, question 48, please.
Yeah. He's bringing the 48 one. Yep, cool, thank you.
Yep.
In 2013, the Commonwealth Parliament passed the Money Laundering Act to implement the International Convention Against Money Laundering, a multilateral treaty that Australia ratified the year before. One of the provisions of the Act required Australian employers to provide new and further benefits to their employees. XYZ Pty Limited, an agricultural company in Queensland, seeks to challenge the Act for being beyond the legislative powers of the Commonwealth Parliament. Advise XYZ Pty Limited on whether its legal challenge is likely to prosper.
My answer, I would advise XYZ Enterprises that its legal challenge is likely to fail. The Money Laundering Act, Commonwealth, being in implementation of a multilateral treaty ratified by Australia, is within the external affairs power of the Australian Commonwealth Parliament to legislate under Section 51, subsection 29 of the Australian Constitution. And you can see Commonwealth versus Tasmania, the Tasmania Dams case, and therefore is valid. That statement tells you the whole thing, the whole argument there. And then I continue. In the Tasmanian Dam case, the High Court also stated that in passing a law in implementation of a treaty, the Commonwealth Parliament may legislate on a subject matter that is beyond the scope of Australia's obligations under the treaty. Now that is a broad statement I'm making. They are my own words, right? Which is why I'm actually now quoting Justice Mason or Chief Justice Mason to prove my point. And Justice Mason or Chief Justice Mason said in that case, there is no persuasive reason for thinking that the international character of the subject matter or the existence of international concern is confined to that part of a treaty which imposes an obligation on Australia. So I made my statement, and because I don't want anyone to question what I said, I'm actually throwing in the weight of Chief Justice Mason. Consequently, it was within the power of the Commonwealth Parliament to also impose rules and regulations on farming and agricultural practices, even if these subjects belong exclusively to the states as part of the Money Laundering Act. You can see the argument there. Now, so finally, once the Commonwealth Parliament legislates under one of its heads of power, in this case, Section 51, subsection 29, it may then validly legislate on a subject matter that would have otherwise belonged exclusively to the states following the engineer's case and Actors and Announcers Equity Association. Can you see that? I think these are exemplary answers. Thank you. Thanks for agreeing. So final example, Patrick. Where are we now? Yep.
Yeah, is that discussion question 48 again? Or?
50.
The Commonwealth Parliament passed the Anti-Corruption Act 2013 that penalises acts of corruption by Australians, including paying bribes to win a government or commercial contract. Jeff Bloggs, a well-known Australian based in Adelaide, was charged under the statute for bribing a government official in China to win a lucrative commercial contract in China. Bloggs seeks to challenge the law on the ground that it cannot be held criminally liable for an act that occurred outside of Australia. Advise Bloggs on whether his legal challenge is likely to prosper.
My answer: I would advise Bloggs that the legal challenge is likely to fail. The Anti-Corruption Act 2013 that penalizes acts of corruption by Australians, regardless of the situs of the crime, meaning the location of the crime, that is, whether the act was committed in Australia or abroad, is within the external affairs power, Section 5129 of the Australian Constitution, of the Australian Commonwealth Parliament to legislate, and is valid. You will notice there that I put in italics the word abroad because I'm connecting abroad with external affairs. You can see the connection there. Okay? So it's flagging to you that this law pertains to something that was committed abroad. If it's abroad, it's external. Now, in Pelikovic versus Commonwealth, the High Court ruled that under its external affairs power, the Commonwealth Parliament may legislate on matters external to Australia. Now, by the way, I'd like to point out rules of grammar here, or rules of writing. You will notice the use of the word it. Where was that? Okay, under its external affairs power. Just be careful when you use the word it or its, because oftentimes in a sentence, you actually have a lot of, subjects. So let's say you would say, the High Court ruled that the Commonwealth Parliament may validly legislate, and in this regard, it can decide to do this and that. Now, we talked about the High Court, we talked about the Commonwealth Parliament, and then you said it. Who is it? What is it? In common English, in that case, it's unclear who it is, right? So if there's only one subject, meaning the one doing the action, that's fine. You can say it or its. But if there are two of them, you need to be clear. Are you referring to this or that? And I would oftentimes flag that in the legal memorandum. The other thing is, again, apologies. I don't want to criticize anyone, okay? Rules of grammar. It's typical for people to say that the law provides that a person who commits a crime will be punished. And then somebody says, now, it means, therefore, that they can do this. So, in other words, I've seen instances where when you're actually referring to a single person, because you don't want to use his or her, which is cumbersome, we just then say they. That's not correct in grammar. Have you come across that? I can't give an example right now, but oftentimes, which is why when I say, for example, to you, somebody's mic is on right now. I need that to be muted. Can he do this? No, I would say, you know what I mean? Joselito Chan. Is it necessary to... Oh, okay. I thought that was about grammar. I hope you know what I mean. If you're referring to a single person, you cannot say they. You might have to say he or him. But people have a shortcut, and then they just say they because they don't want to have to say he or her. He or her, right? Okay, just be clear. Rules of grammar. And because, you're lawyers, you need to be very good in terms of English grammar there. Let me just address this point here. Is it necessary to enter into treaty or agreements with another country to invoke external affairs? No, because, Joselito, there are actually three aspects to the external affairs power of the Constitution of the Commonwealth Parliament. One is the treaty power. That's when you need a treaty or international agreement. The second aspect is the geographical power. So for as long as, like in the case of Pelikovic versus Commonwealth, for as long as the subject is something that resides outside of Australia, meaning it is external, then it falls within the external affairs power. And in that case, obviously, you don't need a treaty for that. Okay. Now, the third aspect is it's if the legislation involves something that is of international concern. So let's assume that there is an international concern now that because of ISIS and international terrorism, the Commonwealth Parliament is passing certain legislation, not using its defense power this time. Okay. Because remember, there's that purposive aspect of the defense power. It would like to use the external affairs power. Can it legislate on a subject that would actually belong to the states using its external affairs power, but that subject is not within a treaty? The answer is yes, if that subject matter is actually of international concern. So it could be about money laundering, it could be about human trafficking, or it could be about boat refugees and so on. So there are three aspects, therefore, to the external affairs power: treaty power, geographic power, and international concern, if you go by the book of Ratapala and Crow. Now, from Peter, and I'm just going to see this, does an act need to specify within Australia and abroad? Or if you specify Australians, this is inclusive of Australians? Yes. Or, okay. Let's go to the first question. Does an act need to specify within Australia and abroad? I'm not sure what that means. It's like the question that I pose. Yeah, if it is a law, and I give an example in a case problem, this is what the Commonwealth Parliament passed as a law, and it does not state anything about external affairs, you cannot make an assumption that, it applies to something abroad. It has to be in the case facts. Unless you can draw your own conclusion that based on what we know, it is something of an international concern. Okay, so it's kind of difficult for me to answer that question there. So I don't know. Now, if you speak about Australians, the assumption is it's an Australian here or abroad. That's right. Or does it simply depend on which head of power is used? I don't really know. I'm not sure, Peter, if I know how to answer that question there. The reason why I see that is because you make a distinction between the power of the Commonwealth Parliament to legislate on the basis of external affairs power and the power of the Commonwealth to legislate in relation to aliens or in relation to immigration. That's another thing. Okay? And that will be crucial as we go to the substantive aspect later on, because as far as arbitrary detention is concerned, or a lengthy detention, I gave a case problem I think in week 11, where if a person is detained, let's say for about 5 days or 10 days by the police, and that person has not yet been presented before the judge, and you seek to challenge the legality of the continuing detention of the police, I argued, and I'm using the word argued, I argued that it is unlikely for the actions of the police to be challenged before the court, because it can be argued that they were still within their power to detain the person. Because remember, what the High Court said in Chu Keng Lim versus Minister of Immigration Affairs was there is a right against arbitrary detention. So you have a right, we have a right against arbitrary detention. We don't have a right against detention. We can be detained, right? But detention that is arbitrary, there is no valid reason for the detention, that is what is constitutionally objectionable. So the question, for example, if you were detained for 5-10 days, is that arbitrary? No, like a police can argue, we're holding you in the meantime to make sure you're not going to commit another crime. We're holding you in the meantime because the judge is unavailable, and then we'll present you to the court in about 10 days. Can you see what I mean? Now, I'm making that point, permanent resident and citizen would have exactly the same rights. Okay, because a permanent resident is no longer an alien. That was the definition of the court in Chu Keng Lim and in Alcatel versus Goodwin. A permanent resident, or somebody, no, not just a permanent resident, but anyone with a visa can really be considered an alien anymore because there is a visa. Okay? Now, what is an alien? An alien ordinary is somebody who has no right to be in Australia. That is an alien. So the alien is broader than the notion of a non-citizen. Okay? Now, in Alcatel versus Goodwin, the High Court, by a majority, actually ruled that an indefinite detention of an alien is permissible. Let me repeat. An indefinite detention of an alien is permissible. So a person who does not have a visa can be detained and put in a detention center in Manus Island by the Minister of Immigration for a period of, let's say, 2 to 3 years. That would be valid and constitutional. Why? Because the court ruled in both Chu Kang Lim versus Minister for Immigration Affairs and Alcatel versus Goodwin that that type of detention is not a punishment. Okay? Now, what we need to remember is that the right against arbitrary arrest or against arbitrary detention, that is a constitutionally protected right in the United States. It's stated there. Okay? There is no such right in Australia. So we have a different constitutional regime in Australia. So, and the court therefore has said that the reason why you might argue that there is an implied right against arbitrary detention, it is because of the notion of separation of powers, in a partial separation of powers in Australia, where there is the judiciary which exercises judicial power exclusively, as opposed to the legislature and the executive. And in Boilermaker's case, it is impermissible for other than Chapter 3 courts to exercise judicial power. And the power to meet punishment on the basis of the commission of a crime has always been recognized to be a function of the courts. So therefore, if the detention does not involve the characterization of an activity as involving a crime or the imposition of a punishment, then the notion of arbitrary detention will not come into play. So that was the reasoning there. What was the other argument there? I'm just trying to think. Yeah, essentially that's it. So it would be different in the United States because, as I said, the rules in Australia are different. Okay, 7 o'clock. Now, I would suggest we've been at it. I've been at it for an hour, and you have been at it for an hour listening to me. You're probably going crazy now. Can we take a break for 5 minutes? So toilet break for a lot of you and for me as well. Make it 7 minutes. And can I just request that for those of you who haven't done this survey, please, can I just ask you to spend 5 minutes to do the survey? And if you could be nice when you do the survey, all the better. Because actually, I'm going to be nice in the final written assessment. I'll make it easy. And I'll tell you why in a short while after the break. But please, so far when we started this, there were about 55 students who answered the survey questions. I'm not forcing anyone to do the survey because it's your right, but it will make me happy. If I don't really know what you're going to say. You can say bad things to me. That's not the point. The thing is, I need you to do the survey, please. And I promise you the final written assessment will be a piece of cake, and I'll tell you why, okay? But let's take a break for about 5 to 7 minutes, and please do the survey, and I'll be back for this, for the break. Thank you. Okay, so we could probably continue. I did see that there were 4 additional feedback. So there are 59 so far who've actually, oh, hold on, I haven't recorded, sorry. Let me just turn the recording back. No, the recording is still on, okay. Where are we now? I did notice that there have now been 4 more who answered the survey. And I would imagine that, you know, most of you or all of you would have been those who constitute the 59 who did the survey. So that's fine. Thank you. Thank you. So we can just continue then. So thank you, Robin. Also need to Chan afterwards. Good. That's fine. That's fine. I'm not forcing you. So thank you. So let's continue now. So we've discussed so far the formal aspect. We're going to go to the substantive aspect, and I promised that you're going to find the final written assessment easier. So let me repeat. In all likelihood, the final written online assessment is actually going to be not a lot easier, but easier than the legal memorandum. Let me repeat. The final written online assessment will be easier than the legal memorandum, even if the final written online assessment is worth 50% of the grade. Yeah, they're going to be easier because what I'm going to do is to use what is known in learning and teaching as scaffolding, in the sense that what we've covered, I will then use that for in coming up with the final assessment. I've actually prepared it already, so that, you know, what we did cover, for example, in this session, these 5 things, these are the very ones that will then be covered in the final written assessment. So in other words, there will be no surprises. No surprises. You know where we're headed because we've covered it tonight. Okay. Now, I'm not gonna make it so easy that you're actually gonna know what the answer is. That won't be allowed. But you know, you will have a good sense of where we're headed. No surprises. Okay. So no surprises there. So judicial power and matter. I'm gonna go back to this because there was only one student to actually answered question 2 correctly. So let's just go back to that. What we need to remember is that in the Boilermakers case, the High Court had said, so we're now going to the substantive aspect, right? So the High Court had said that judicial power can only be reposed or vested in Chapter 3 courts. That was clear, okay? So judicial power can only be vested in Chapter 3 courts, and non-judicial power cannot be vested in Chapter 3 courts as well. So that was the corollary there. Now, the problem, however, is how do we know when judicial power is to be exercised, right? When do we know? So that's the crucial point. And that's when we bring in the definition of Huddart-Parker versus Moorhead of when judicial power is being used. And judicial power, according to the Constitution, only arises when there is a matter. Right, scaffolding, subcontracting, yeah. How did that Viagra come up? That's something else, Peter. Huh.
Yeah, he came up well.
I don't need that. And I hope you don't either. Now, moving on. So the thing is, matter is important because judicial power can only be exercised when there is a matter, right? If there is no matter, so that's a crucial point. Remember, if there is no matter, judicial power cannot be exercised, according to the Boilermakers case. And if there is a matter, non-Chapter 3 courts, executive officers cannot make a decision on that. So that's crucial. Clear there? Now, so we go back to that question, what exactly is a matter? At the very least, a matter involves an actual controversy involving the citizens and the state, or 2 persons, 2 subjects of the state, or it could be the subjects and a corporation. There's an actual dispute, controversy. There's a fight. Okay, now, in other words, if there is no controversy, if there's no actual controversy or there's no actual dispute, there is no matter. So therefore, in other words, the word matter has a distinct legal definition in constitutional law. We're not using it in an ordinary sense. There is a distinct meaning of what matter is as defined in Haddard Parker versus Moorhead. So as an example, let's say the police, there is a law where the police can arrest and detain a person who is about to commit a crime. Okay, and detain that person for a period, let's say, of 15 days. Now that power, the question is that power to detain and arrest, does that involve a matter? No. There is no dispute there. There is no controversy. But when the police arrest the person, now there is a controversy. My rights as a citizen have been violated. You're arresting me. You're detaining me. There is a controversy. Now, let's look at civil law. The basis of a contract is always consent or an agreement between parties. And let's assume that because the contract, and this was in the example anyway, because of the contract involves millions of dollars, we want to be sure that everything is above board. We want to be sure that every single provision there in the contract is according to law. And we don't want a contract to be struck down by the court as being invalid because it violates some legal principle or law. Now, so what we're interested in doing is why don't we just bring this to the court and say, Your Honor, we're not sure whether this particular provision is valid. Can you please enlighten us? Or it could be we're husband and wife and we're not too sure. We decide that, why don't we do this? We can't seem to agree on who has custody of our child. Is it possible that, I pay you $2,000 and then, I pay you $50,000, then give the custody of our child to me? Okay, so let's sign this agreement on our own. And the question then is, but before I pay you the $50,000, I want to be sure though that that's actually a valid provision or a valid stipulation. Because I don't want to pay you $50,000 just to learn later on that what I did was actually wrong or illegal. So you want to go to the court. Is that allowed? Was there a matter there? Or let's say you agree, okay, I'm interested in, you're thinking, why don't we agree that we will cheat the casino? And, I'm going to supply you the machines and to allow you to cheat. And if you do this, I pay you this much. So let's have that agreement. But hang on, hold on. Are we even allowed to do this? Can we enter into this agreement? But to be sure, why don't we bring this to the court? Question, was there a matter there? In those instances, there was no matter, there was no dispute. Now, when something has happened and, there seems to be a breach of contract, there is a matter. And because there is a matter, it can only be done by the courts. At that point, there was no controversy then. But the moment there's, somebody breaks a contract, there is a dispute, there is an actual controversy, it becomes a matter. Now sometimes you will ask, why is it that, if you go by the Intelligence Surveillance Act in Australia, Commonwealth, why is it that they would, we would use eligible judges, or what we call the persona designata doctrine, where certain officers of the federal court or the federal courts are asked to sit in an administrative tribunal for the purpose of, issuing a warrant to arrest a person, or issue a warrant for the purpose of intercepting communications, or for the purpose of wiretapping. So in other words, in particular, what if there was a law that said, this law authorizes the Minister of Police to have the power to listen into the communications of individuals. Okay, what if that were the law? The question then is, would there be a matter? Yes, where there is actual interception and surveillance, there would be a matter. That would be a controversy there. But the point I'm making is, why is it the case that oftentimes, they would have to get a judge at the federal court to sit in one of these, for the purpose of issuing the warrant or to authorize the surveillance. The reason is what the executive or the legislature is trying to do, the legislature being part of or the executive being part of the legislature, because remember, it's the prime minister and his cabinet to control the legislative agenda because they constitute the majority there. What they're actually attempting to do is to use the image or the reputation of the court for the purpose of sanitizing, making look nice what the police is attempting to do. Because remember, it's different if it's the judge issuing it. Even if the judge is issuing it not as a judge, but actually as part of an administrative tribunal. So it looks nice. Yeah, that's also the thing, because judges have credibility, they're also impartial. So it's a way of sanitizing, okay? So that's why they employ judges for that purpose, because it looks nice. It gives them credibility, and judges typically are impartial. And, and that's correct, as Kylie said, you don't want to leave it to the police, so may just decide to do this and that. At least there is somebody impartial there. Okay, so clear enough? So I think that's clear about judicial power and matter. Yeah, so for as long as you know matter equals actual controversy, you'll be fine. Now, moving on, taxation, I'll be focusing on the notion of license fee, excise. So the crucial point first is that if it is a law of taxation, the rule is that the law must only pertain to taxation and nothing else. So what the law is saying in section 55, isn't it? Yep, in section 55. What the law is saying is actually that if it's about taxation, we must avoid tacking other things. Don't put anything else other than taxation in that taxation legislation. There is a historical reason for this, especially in the United States, because what would typically happen is that in the United States, for example, and tacking is allowed in the United States, by the way. What typically happens is that, let's say they pass a law concerning taxation, okay, and they would like to impose a tax rate of, let's say, 50% or whatever. And you know how it is in Parliament. They negotiate, there's a lot of, backroom dealing going on. And then they'd say, okay, I will let this tax law pass, but you need to do this for me. Okay, you have to insert something that, you're going to grant this blah, blah, blah to my constituency. So in other words, a tax law is a crucial piece of legislation always. Okay, it's always a crucial piece of legislation. And because it's so important to the ruling party in the parliament, they want to make it pass, and they want the support of every single parliamentarian. Oftentimes in the United States, what they would do then is, I will support that tax law on the assumption that you tack this into that tax law. They do that in the United States. Okay, as a way of so the only way that somebody is willing to provide support to the tax law, even if they don't like it, is if they're willing to do this for their constituency. Okay, in Australia, that is not allowed. To avoid tacking, if it's a tax law, it should just be about tax. Now that's crucial because for two reasons. What was that? Isn't what Julia did with the Greens to form a majority government? Yeah. So there's a lot of backroom dealing going on now. So that's crucial then, because it's possible that there is a law, whatever it might be, a law on insurance, or it might be a law on banking. Okay, so the law is really on insurance. The law is really on banking, and in the process, there is a financial amount that is involved. So they're saying, we impose a license fee for this, or we impose a charge of this side, or because we were trying to do this, we need to be able to generate some revenue. Okay, so that can happen. And then you begin to wonder, this is a law on insurance or banking, and then there seems to be a financial component involved, an amount of money that it needs to be paid. You need to know, does that constitute a tax? Because if it constitutes a tax, as defined in Matthews versus Chicory Marketing Board, then you have a situation where you have a single law where you have insurance or banking and then a tax matter. Clearly a violation of Section 55. Right? Now, but before you even, but even if you say that it is a tax, okay, before you say it is a tax, you must make sure though that that is not a license fee. Because a license fee, actually meets the definition of a tax, right? A license fee meets the definition of a tax. It's a compulsory exaction of money by a public authority for a public purpose based on the law. Now, so license fee meets the definition of a tax. So to make sure that that amount of money that's being sought to be paid by whoever is not a tax, it might be argued that it is a license fee. Okay, so if you're talking about an amount of money being a tax and it violates Section 55, you need to argue in that same answer why that exaction is not a license fee. You need to be able to explain it away. This can't be a license fee, but it's really a tax. And the only way to do that is to say that if it is a license fee, then that amount of money must be commensurate or be proportionate to the value of the cost of doing this or to the value of the services that are being rendered. Okay? Because anything over and above the value of the cost of implementing this regulatory scheme, or over and above that the service is being rendered for the purpose of providing the license, that excess will have to be a tax. And it would violate the...
Manjo?
Yes.
Just on that point, who is the onus on? If someone was to argue that, how can they get the requisite evidence to say that the costs of providing a scheme by the government aren't commensurate with the cost of, what the license fee is from all the other people who are having to pay the license fee? Does the government have to, does the court make the government provide evidence?
It will boil down to evidence, yes. Yes.
So it's not up to the plaintiff to have to come up with all this evidence to then, the burden isn't on them to prove that it is incommensurate.
In the first place, because you're the one applying, you're trying to get the law to be excessive, you must be able to make a statement so that the court does not throw away your application, that is excessive. So you probably, in your pleading, you're already saying that in all likelihood, based on what we know, expert evidence, the cost of doing this should only be this much, and yet this is what the government is asking us to pay. So it's not something theoretical in your mind. You are backing yourself up with certain evidence. Okay, now going to the facts, assuming it were a case problem, you don't really know how much exactly is the cost, but actually you will have an idea. If it's about regulating the distribution of milk or the distribution of newspapers, you can't be saying that everyone who goes into the business of distributing newspapers have to pay an amount of $1 million. That's absurd. You know what I mean? Now, assuming that you're not really sure, assuming you don't really know for sure, then in that case, make your case. Say that, when you look at this has got to be excessive because surely the amount involved in doing this should be only about $10,000 or so. You're still making your point, but you're providing the context for your argument by making a factual assumption. Okay? Clear? Now, the notion of license fee, as we said, is also crucial because of Section 90 of the Constitution. And this is because under Section 90 of the Constitution, excise or excise taxes can only and exclusively be imposed by the Commonwealth Parliament. So states don't have the right to impose excise taxes. Now remember, an excise tax is essentially a tax on good, a tax on a good or a tax on a product, right? So it's like the GST or a tax on a service. Not service, but it's a tax on good or a tax on a production of a product. Now, that's a source of money. That's a source of revenue. And that's always a problem between the state and the Commonwealth Parliament. The states don't want to be dependent on the Commonwealth Parliament, especially because states have the responsibility of providing for the welfare of its, the subjects of the state. So they pay for education, they pay for the roads, they pay for health, and so on. They don't want to be overly reliant on the Commonwealth Parliament to always, dish out money to them. And so they want to be able to raise money on their own. But the problem is, the easiest way to do that actually is to provide an excise tax. But they're not allowed to do that. So, and that's where the tension often happens. So there might be a scenario where it could be, the state parliament passing a law, and you know that it is a tax, but they're actually saying that it's a license fee. So you need to figure out that license fee that the state is saying that it is imposing. You're going to make an argument that actually that license fee is not a license fee. It's actually the nature of an excise. And how do you know that it's in the nature of an excise? Because that exaction corresponds to the actual aspect where there is a sale of a good or a product. And not only is it a question of a sale or of a product, but it involves the aspect of the distribution or the manufacturing of the good. So it's actually kind of a trading tax. So that's what an excise is. Okay. So, and then, you cite Air Caledonia, Matthews versus Supreme Marketing Board. I'm not going to make it, the exam question, not the exam question, but the assessment question on this point is not too complicated. So I'm not going to go into that aspect of, the amount of blah, blah, blah is based on sales 2 years ago. And do I go into that? Because in the case of Dennis Hotels, the High Court was saying that if there is an exaction of money, but it is based on previous not sales but previous purchases, then in that case it's not correlated with sales. Then it's not a tax, and therefore it's not. It is a tax, but it is not an excise because it is not a tax on goods. I'm not going to go into that because that might be too complicated. So I'll make it a bit simpler. Okay, so that's essentially what it is about taxation and license fees and excise. Okay, yep, it will be in Moodle. I'll put it up in Moodle. Now, so good, Janet. Now, yes?
No, excuse me. Because you're saying an excise is generally attributed to goods, it's a sale of goods. If a state government put a license fee in the form of that seemed to be an excise on the provision of services, is that something that is too complicated to be in the, you're saying excise is for goods but not services.
That's right.
Okay, so all right.
Yeah, so a service is not a good. I mean, in marketing, service is a good. But remember that at the time that of federation, the idea, there is a traditional notion, a historical notion of what a good is. And in olden times, not really olden times, but prior to federation, meaning the framers of the Constitution, when they wrote this provision, their idea of a tax, an excise tax, has to be based on goods because it says customs duties. The duties of customs duties are imposed on products, not on services. Okay, and you will see that that's the way that the High Court has actually defined Air Caledonia. In Air Caledonia, for example, it's always on goods. So, therefore, if the state governments will impose a tax, I'm not even using the word license fee. If the state government imposes a tax on services, that won't be an excise. That will be valid. It won't go against Section 90 of the Constitution. Okay?
Okay. Yes. Okay, thanks.
So at least you know that difference because I might just throw in that question. So it's easy to answer. Tax, it's not a tax on goods, tax on services, that's fine. Okay, good. Now, federal-state relations. Okay, freedom of trade and commerce is guaranteed in Section 92. In the first place, remember that the individual rights approach was rejected in Cole versus Whitfield. If you look at the notion of the individual rights approach, the initial understanding of the notion of freedom of trade and commerce as guaranteed in Section 92 was that if it makes it difficult for a trader of a state to be able to trade within Australia, even if that law actually applies to everyone in Australia, the fact that it makes it difficult for a trader to trade in Australia, that would be invalid and unconstitutional under the individual rights approach. Meaning that was the initial interpretation of Section 92. Now, the High Court, however, in Cole versus Whitfield, clarified that that's not correct. It's not about the individual rights approach, but what we have is called the free state the free trade approach, in the sense that for as long as a law applies equally to all states, it does not discriminate between the states, even if it makes burdensome, even if it makes trading by a trader burdensome. It makes it difficult for him because he's probably going against a monopoly created by a state. There is no violation of the freedom of trade and commerce because of the notion of the free trade approach. Okay, so that's Cole versus Whitfield and Castlemaine-Tooheys versus South Australia. Now, more importantly, what if there is a law that discriminates? Was there a question? Oh, okay. So what if there is a law that, in a sense, is discriminatory, in the sense that it discriminates probably against one state? Okay. The idea there is that what is not allowed or is prohibited under Section 92 is what is known as relevantly discriminatory. So the only time it will be so discrimination per se is allowed. Okay. So it's possible to discriminate against the states. So in other words, in a sense, the trading so it's possible that it applies equally to all states and it burdens all states. Okay? It burdens all states. So in a sense, because it burdens all states, in a sense, it goes against the idea of freedom of trade and commerce because there's a burden. Okay? That is fine. The High Court said in Cole versus Whitfield, that is fine. For as long as that burden is not relevantly discriminatory. And what relevantly discriminatory means is that that burden that is being imposed on the freedom to trade across states. There's a mic there that needs to be kind of muted. So even if there's a burden on interstate trading, that is fine if the purpose is regulation. So you want to be able to regulate, for example, the sale of guns, or the sale of certain drugs in Australia. It burdens, obviously, trade and commerce. So, in other words, there is a freedom of trade and commerce, but it is not absolute. There are certain prohibitions. You cannot trade in illegal drugs. You cannot trade in firearms, or you can't trade in whatever contraband, your weapons. Okay, that obviously is a limitation on trade. It's not absolute freedom of trade and commerce. Okay, that's guaranteed. So burdens may be made for as long as they are not relevantly discriminatory. So relevantly discriminatory for as long as they are not protectionist. Okay? Now, even then, even assuming that, in a sense, you might say that it is protectionist, that's fine for as long as it can be argued that it's actually within the framework of a regulatory environment. You're actually trying to protect something. So that's why, in a sense, you say it's protectionist. But the real purpose is not protection. The real purpose is the regulation. The protectionism is only an incidental effect. Okay? That's still fine. And especially if you can argue that the means you're using for the purpose of achieving a governmental purpose of regulation is proportionate. Okay, so the means employed are proportionate to the goals. So that would be the freedom of trade and commerce. Now, moving on, external affairs power and the defense power. So if you go by the external affairs power, we must remember that following the engineer's case and following the decision of the court in Polukovich versus the Commonwealth, external affairs power has to be interpreted broadly. Okay? So what it means is that once the external affairs power is triggered, meaning it is used, once you can say that you can use external affairs power, then it would then be permissible for the Commonwealth Parliament to legislate on other matters, even if they are not directly connected to external affairs. So if, say, there is a treaty that Australia that enters into with China, the treaty might be about business. And as a result, the Commonwealth Parliament then implements the treaty in the form of a legislation or in the form of a law, and then it passes a law pertaining to education, which has really not much to do with the business, okay? But the fact alone that there is a head of power on which the law can be staked on or grounded, it would then be permissible to kind of legislate on matters outside of that external affairs, and therefore legislate on a subject that would have belonged exclusively to the states. there's a question from, does the Commonwealth have to state the head of power they are using when making legislation, or does it only come up? No, there's no requirement. Certainly there is no requirement that the Commonwealth Parliament has to say, we're using this head of power. There is no need, they don't have to do that. But if you wish, you were planning on challenging a law, then you need to figure out first, before I challenge the law, I have to make sure, is it possible for the Commonwealth Parliament to be able to claim its right to legislate on the subject on the basis of a head of power that's given under the Constitution? So that's the kind of question you're asking, but the Commonwealth Parliament doesn't have to prove anything. Okay, it's assumed it has the power. So that's external affairs. Interpreted broadly, 3 aspects to it. Treaty power is the first one. If there is a treaty, remember, a treaty is not part of Australian law. Okay, a treaty, an international instrument, is not part of Australian law because the power to enter treaties belongs to the executive. It could be the Prime Minister, it could be the cabinet, it could be a cabinet minister who enters into a treaty with another country. Okay, now for that to become law, that treaty must be incorporated. So that's called the incorporation approach of international law. That treaty must then be incorporated in a domestic legislation for it to become part of the law of Australia. So therefore, what typically happens is, if there is a treaty, there's typically an agreement there that that treaty should be embodied in a law in Australia and for the other party as well. Because otherwise, it would be useless. It's just going to be a declaration of principles. So for the contents of that treaty to become part of Australian law, there's usually an agreement that should then become part of domestic, meaning Australian legislation. So that's the treaty power. But the other aspect of the external affairs power is the geographical power, that for as long as it pertains to subject matters outside of Australia, meaning the geographic location is outside of Australia, or it pertains to Australian subjects doing things abroad, then the external affairs power can already be used. There is no treaty in that instance. The fact, however, that the legislation pertains to something that occurs outside of Australia geographically, that would be sufficient for the external affairs power to have been triggered. Okay, and then you interpret it broadly. So in other words, the problem always is, why is this important in the first place? Because using the engineer's case, the broad expansionary consequences of the engineer's case, the Commonwealth Parliament is able to use its powers to intrude into subjects that should have belonged exclusively to the states. Because remember, in the setup that we have in Australia, the Commonwealth Parliament has only the power to legislate on those subjects that are expressly found in the Constitution. Limited. Okay. Good night, Ian. So the Commonwealth Parliament is limited in terms of its ability to legislate on those that are found in the Constitution. Everything else is understood to belong to the states. So that's why the Commonwealth Parliament cannot legislate on the environment, cannot legislate on education, or in relation to hospitals. It cannot, except for the constitutional prohibitions, right? So both the state and the Commonwealth Parliament cannot legislate on matters that are constitutionally prohibited, either expressly or impliedly. Does that apply to interstate? Yes, because if, for example, the Commonwealth Parliament passes a law concerning interstate trade in Australia under Section 51, subsection 1, then it can already legislate in relation to intrastate trade. So it can affect already the activities within a particular state by citing the Trade and Commerce Clause of Section 51, subsection 1. Now, so that's the external affairs power. The external affairs power is then used to intrude into fields or subjects that would have exclusively belonged to the states. Now, so that's the treaty power, geographic power. The third aspect of the external affairs power is known as the power concerning international concerns. So international concern. In this aspect, even if there is no treaty, even if it does not relate to a subject matter outside of Australia, meaning geographically, if it is one of an international concern, let's say human trafficking across nations or international terrorism, the Commonwealth Parliament may then have the power to legislate on that subject, and in doing so, touch upon fields or subjects that exclusively belong to the states. So that's because it is of an international concern. Now, how do we know what is of an international concern? Now, it's a matter of evidence. Okay, there will be a general agreement that this is something that is of international concern. Like we could agree climate change is of international concern, right? We could agree that both refugees, the issue of both refugees is of international concern. We could agree that war crimes is of international concern. We could agree that, money laundering is of international concern. We could agree that the need to control illegal drugs is of international concern. So even if there were no treaty, even if there were no, even if the law did not actually pertain to activities outside of Australia, if it could be said that, if it could be argued, so I'm using the word argued, if it could be argued that that is of legitimate international concern, then the Commonwealth Parliament can legislate on that, even if it doesn't really belong to it in the first place. So that's one. So even if it's not, so the power, for example, about, to control, well, drugs would be obviously trade and commerce, but, assuming that there is a subject that doesn't belong to the state, but because of it is an international concern, like climate change, okay? There's nothing in the Constitution that the Commonwealth Parliament can legislate on climate change. Agreed? It's not there. I mean, in the 1900s, no one knew about climate change. Okay? The question is, does the Commonwealth Parliament have the power to legislate on climate change? The answer is yes. There is no treaty. It's not really about something happening outside. In fact, the law pertains to Australia. But if there's a connection with climate change, which is of international concern, then the external affairs power can be triggered. Clear? Now, we contrast that with the defense power because they typically go hand in hand. Defense power in the Constitution, Section 51, is the only one which has a purposive approach. So the High Court has stated in Stenhouse versus Coleman and the Australian Communist Party case that if the defense power were to be used by the Commonwealth Parliament, the subject of the legislation must clearly be for the purpose of enhancing the defense of the Commonwealth or that of the states. There has to be a purposive aspect. It has to be for the defense of the Commonwealth. In other words, if the legislation using the defense power does not in any way enhance the defense of the Commonwealth or the states, then it fails that test, assuming it's the defense power that's being used. That's crucial, for example, because, as I said, and this might appear in the final written oral assessment, assuming that the law is passed that allows surveillance, extensive surveillance of the communications of all Australians, the ability to, they could wiretap into our phones, they could listen to all our chats, listen to all our discussions, look into our Facebook pages, because they can do that. And they use the defense power for that purpose, okay? For the purpose of the defense, because they think they've heard of, that's it's a threat. In fact, the jihadis are, are discussing how to attack Australia using the internet. And because it's so difficult to figure out who is doing what, why don't we just have the ability to look into the emails of everyone and tap into their phones? Question is, would that kind of law be valid if they were using the defense power? Now, the thing about the defense power is, one, firstly, it has to be for the purpose of enhancing the defense of the Commonwealth or of the state. So you begin to wonder, is that even effective? Does that even relate to defending the Commonwealth? How does tapping into my phone or the phone of my son or looking into his email or the email of my young daughter have to do with defending defending the Commonwealth or the states? And you probably say, it doesn't make sense. It's not for the purpose. In that case, you could attack that law. But secondly, oh, by the way, and I forget, as far as Thomas versus Mowbray is concerned, the High Court already ruled that the notion of the defense power is not limited to the notion of defense of the Commonwealth against external enemies. It can be used to combat domestic terrorism. So it's broader. It's not about having an actual war. There doesn't even have to be a war. The defense power can be triggered already. So the defense of the Commonwealth also includes, in Thomas versus Mowbray, the ability of the Commonwealth Parliament to protect itself against internal enemies. Now, moving on. The second aspect of the defense power, more than the fact that it has a purposive requirement, is that there must be reasonableness or proportionality of the means being used. So assuming that the desired purpose meets the requirement that it is for the defense of the Commonwealth, the question is, this measure, the means that you're using, is it actually proportionate to the goal that you're trying to do? So if your goal is actually to combat terrorism, why do you have to tap the phones of everyone else in Australia? It's not proportional. It's like your goal is to kill an ant, and what you do is to use a baseball bat. Or use, in the case of North Korean leader Kim Jong-il, he was so angry. There was one time, and it's in the news, and this is not apocryphal, it's true. It was in the news that he had this general, so, I suppose you know Kim Jong-il, right? He is the great leader of North Korea. Oh, and I hope doesn't get angry with me. But in one of his meetings, a general was, one of the generals fell asleep in one of his meetings when the great leader was there. You know what he did? He got so angry, he had the general posted somewhere there, and he used a missile to kill the general. I'm not joking. Now, that's an example of reasonableness and proportionality. So you have to make sure that whatever means or measures are being used would be proportionate to the goal that is being sought to be achieved. Now, finally, constitutional rights and freedoms. Let's begin with the understanding already, which I mentioned earlier, that there is a recognition on the part of the High Court, the case of Chu Keng-lim versus Minister for Immigration and Ethnic Affairs, that there is a constitutionally protected right against arbitrary detention. So detention per se is valid. What the Constitution impliedly prohibits is detention that is arbitrary, meaning it has there is no valid reason. So a detention for the purpose of
Manjo,
yes?
sorry, can you just repeat the case, please?
The case was Chu Keng-lim versus Minister for Immigration.
The Lim case. Okay, thanks.
Yeah, the Lim case. Yes. So there is an implied constitutional right against arbitrary detention. So it is not detention per se. So the police can detain an Australian citizen for a period of, let's say, 10 days, and they didn't get a warrant from the judge. It's unlikely for that detention to be unlawful. It is likely to be lawful if there is a valid ground that the police can say, and they can argue that, we detained him for 10 days, one, because he was about to commit a crime, and if we didn't detain him, he was going to pass on information, or he was going to provide material support to, somebody who was going to blow up towers in Australia. So there is a valid ground for that. Or they were holding him because they were just holding him for the purpose of then presenting him to the court. So there is a valid ground for that, okay? Now, however, the longer the detention is, if it extends like to 15 days or 20 days, you begin to wonder, what's the point of detaining him without getting sanction or approval from the court? So I would argue, and I'm using the word argue because there is no case law on this, I would argue that perhaps, if somebody were detained by the police for a period of 10 days, maybe even 15 days, it's difficult to claim that the detention was unlawful or arbitrary. But going beyond that, you begin to wonder, that has got to be wrong. You should have gone to the court. Are we clear? I'm using the word argue because there is no case law on this. But I could make the claim that if somebody were detained by the police for a period of 10, 12 days, it's arguable for the police. The police could argue that it's actually valid because they were just waiting for the judge to be available. They were just waiting to make sure that this guy does not provide, the crucial information that was going to be used by some domestic terrorists to put bombs in Australia. Okay? Now, the crucial point, though, is that in Al-Khatib, AL-KATIB versus Goodwin, the High Court ruled that the notion of arbitrary detention does not really apply if one is an alien. And who is an alien? A non-citizen or somebody who does not have a legitimate right to be in Australia, meaning that person does not have a visa, okay? That would be an alien. So in other words, an Australian permanent resident or an Australian visa holder on a 457 visa, somebody on a 457 visa will be covered with the protection against arbitrary detention. The High Court ruled in Al-Khatib versus Goodwin, though, that if somebody is an alien, it would be permissible for the executive to indefinitely detain a person, even if it may last 2 to 3 years. So you will see instances now of both refugees being locked up or detained because their movement has been diminished or impaired. being detained in Manus Island or whatever detention facility, and they're even using the word detention facility, they've been detained there for quite some time without any criminal charges having been made. What's going on? The High Court ruled that is valid because, in the first place, arbitrary detention does not, the right against arbitrary detention doesn't really apply to aliens. It does apply to citizens and lawful subjects of the Australian Commonwealth. And more importantly, detention in that instance is actually not a punishment. The purpose why they're there is because the executive government, the Minister of Immigration, is determining should a visa be granted. So that's the reason. It is not a punishment. But if you can argue that the detention is in the form of a punishment, then the Boilermakers case is triggered because the High Court has ruled that as far as the power to adjudge guilt or innocence belongs exclusively to the courts. And which brings us to the notion of Bill of Attainder shortly. So if it's a question, therefore, of meting punishment, a punishment for a crime, that belongs exclusively to the courts in the Boilermakers case, because the court has been quite clear that there are certain functions, and one of them is the judgment of guilt or innocence that pertain exclusively to the courts, even historically. Okay, it was always the courts who made the decision whether or not somebody was guilty. Okay, so that's quite clear. So in other words, if you're talking about continuing detention and the facts are not clear whether that person is a citizen or not, then you make an assumption. I make an assumption he is a citizen, this is the answer. But if you were actually an alien, chances are if that person were detained for a period of 1 year, that will not violate a constitutional prohibition against arbitrary detention, because in Al-Khatib versus Goodwin, the High Court ruled that it doesn't apply to in the case of aliens, because the detention of aliens would be for the purpose sanctioned by the Migration Act, for the purpose of determining whether or not a valid visa should be given to that person in the first place, and for the purpose of ensuring that whether or not the Minister for Immigration should forcibly deport a person out of Australia. Okay, now moving on, Bill of Attainder versus ex post facto. Do I have to do this or we're done? I've gone through this. I'll just make it quick. Okay, Bill of Attainder, it means that the law specifies a group of persons, and you can remember Fardon, the case of Fardon, where if a law specifies a specific person or a set of persons as having committed a crime or an offense, and therefore punishment is meted to them, then that means that it was actually the legislature that determined the guilt of that person or group of persons, and because it imposed punishment. And this applies both to the Commonwealth Parliament and to the states. Okay, it applies both to the Commonwealth Parliament and to the state parliaments, the right against bills of attainder. So, however, if it leaves it to the judiciary, to determine on the basis of whether or not this person is subject to punishment, because the judiciary still retains that power to determine guilt or innocence, then there would be no violation of the law against bills of attainder. So bills of attainders are prohibited. Ex post facto legislation, as I already made clear earlier, in the case of Polykovich versus Commonwealth, is valid because there is no express constitutional prohibition in our constitution, because we don't have a Bill of Rights. There is no express constitutional prohibition against ex post facto legislation. And the High Court was unprepared in Polykovich to read into the Constitution a limitation concerning ex post facto legislation. So therefore, they said that it was open to the Commonwealth Parliament to legislate in such a way that acts that were previously valid were then criminalized. Okay, but then you ask, why would that be permissible? Doesn't that violate, the Boilermakers case? The answer is no, because even if it was actually an ex post facto legislation, meaning it was retrospectively applied to certain acts, it was left to the court still to determine guilt or innocence in the first place. So fine, you criminalize actions, certain actions that were valid in the past. But in the end, the one who determines guilt or innocence, the one who imposes punishment will still be the courts. That's why there is a violation of the Boilermaker's case. So I think you should do well in the final written online assessment. Will there be any questions before we end this? And this is going to be our last tutorial. Any questions before we go? And it's 7:55, 5 minutes to 8. How many questions in the assessment? 4. 4 questions. Actually, constitutional rights and freedoms, or they put it as number 5, will be covered in the defense power thingy there. Or it could be covered in the matter concerning about matter. There will only be 4 questions. Oh, salamat. Yeah, thank you. Salamat, which means thank you. So I guess that's it. Thanks, everyone. I enjoyed teaching this course. I hope you do well, and I'm sure you will do well. Please make sure to go through the lecture notes and go through the suggested answers that I have, because in those suggested answers, you already have a strong insight on how to answer questions, okay? Participation marks will be up hopefully before the end of the week. I don't know, by the weekend. Thank you. Good night. And for those who haven't done the survey yet, please do so. Good night. See you soon. Thanks for being fantastic students. Bye.